Lovely, lovely. Good morning, dear friends. It's a pleasure to have you all as part of this webinar being co-hosted by Sadgamaya, Symbiosis, Lex Witness, and THS, the law firm. I would like to start by first of all thanking the COVID warriors, as we call, from the doctors to the police and all the government machineries who have been making our best, giving the best effort to keep us safe at home. Just as a precursor, we have a question answer session, which you can keep on posting on the your question answer portal. But raise your hand, that will be addressed by the moderators. I will start by first introducing the panelists. The best thing is that with the panelists which we have, they don't need much of an introduction. However, briefly speaking, we are blessed and pleased to have Justice B.D. Ahmed as one of the panelists, who is one of the finest judges who have passed many judgments on the commercial laws aspects. We have Mr. Venkatramani, sir, who is well known in the legal profession. Apart from being a member of Law Commission, he has written a statement of the law books of the Supreme Court. We have Manish, Lamba, a very prominent general counsel and speaker, which we all are familiar with. We are also happy to have Chandra from WhatsApp, who will be dealing with the new age technology, much sought after speaker. And we have Meenu Chandra from HCL, who will be dealing with the IT industry and all the sectors. With this brief introduction, I would leave the house open for discussion and request Venkatramani sir to start with the session.
You are muted, sir. You'll have to.
You are mute. So thank you, Alok, and thank you all the panelists, and particularly I must thank Justice Ahmed for joining us today. And when you are trying to remember all the COVID warriors, I think it's my duty also to remember Professor Yadava and to pay homage to him. It's just a year ago that he left us, and many of us might have been his students, and I happen to be a student. And I think we're missing Professor Meenu at very critical times. So let's pay homage to him for the great visionary and great teacher which India has seen in recent times. Now, having said that, many of us, I think, are drawn into very serious and concerned engagements about the developments in the past 2 months. We did not go into the history of what is happening. But then the unforeseen issues which have emerged and the consequences which are facing in everyday life. Trade, industry, common men and women, and beyond trade and industry, our personal problems of life and so on and so forth. So there are several issues which are grappling our imagination, and then all of us understand that we are in need of very innovative, novel, creative, but at the same time fair and humane solutions. And to balance between a fair and humane solution, at the same time balancing other social, economic, and other interests is a very difficult job. I think the government will be walking a very tight rope. And I don't know whether we have any textbook answers available for answering many of the questions which are emerging now. But the engagement today is to set in motion a series of thinking process. There's a larger number of questions keep coming to me, and industry and business keep asking questions over a period of time. So let me quickly gather the points, I think, like a bullet point, presentation, having regard to the paucity of time we have. I think, in my view, some of the questions which have come to me, I would like to bracket them in the following way. Whether the Disaster Management Act has all the answers to all the issues arising from the lockdown. Whether the invocation of the Act to impose obligations or duties pertaining to employment and payment of wages is permissible. If the Act could not be so invoked, whether trade and industry can organize their affairs in respect of the above by acting within the relevant legislations, such as the Payment of Wages Act, the Industrial Disputes Act, Employee State Insurance Act, and so on and so forth. I find that these issues have come in the context of questions relating to, one, obligations under industrial and labor laws, and two, obligations generally under contracts. Answers to these questions will first require examination of the constitutional and statutory provisions. I don't propose to go into it in greater length, but briefly touching them. Under the federal scheme of the Constitution, there can be no doubt that the central government is competent to have passed the Disaster Management Act. There is also no doubt that the central government can require state governments to comply with its orders and directions under the Disaster Management Act. You can briefly refer to Articles 256 and 257 of the Constitution of India. I proceed to further saying that there's also no doubt that then none of the labor and employment-related legislations provide any framework to deal with the claims and the demands arising from the lockdown. For instance, even a strained reading of these legislations, in my understanding, does not lead to any non-contentious solutions, even though one may find a limited answer. For instance, in the context of layoff under the Industrial Disputes Act. So these legislations have not conferred any power on the appropriate government, including the central government, to issue compelling directions or reliefs, whether to the industry or to the labor or employee in situations such as disaster management. Reciprocal performance, I think very important. Reciprocal performances are the underlying principle of mutual obligations of work and pay, or possession and rent. Ordinarily, no performance, no obligations. But the obligations relating to payment of wages and non-eviction of tenants have been imposed as if there is no actual disruption of any activity, economic or otherwise, and as if there is reciprocal, continuing reciprocal performance. However, there is an actual disruption and an actual non-performance of reciprocal obligations. For fault that cannot be attributed to any party, we are faced with some tough questions and tougher answers. In my view, I just give a quick glance at the Disaster Management Act. In my view, the Disaster Management Act only provides for all measures of management of any disaster, including mitigation of the disaster itself. In the current scenario, the lockdown is the mitigation measure which is contemplated under the Act. Prima facie, the Act does not go beyond this, namely the authority to mitigate the disaster. It does not appear to confer on the government to issue directives dealing with economic consequences arising out of, for instance, the lockdown. So the imposition of a lockdown as a mitigating measure is one thing, but dealing with consequences arising out of this mitigation disaster is yet another thing. If the Act only contemplates the former and not the latter, we have some serious questions to ask and answer. We shall be exploring this and then possible steps that the industry can take on their own. Then on contractual obligations, so far as frustration is concerned, we have received a large number of questions. As frustration is concerned, the state of Indian law will be of very little assistance in my view. This law is stated in 4 Supreme Court judgments. I will not refer to them right now. But then I want to make it one thing clear, that the standards for having regard to the state of Indian law, that the standards for invoking frustration are extremely high and rigorous. Then is there a room for a wriggling out? Perhaps in limited circumstances. We can explore them, all of them now. On force majeure, I think we can profitably exploit the notification of the Ministry of Finance dated 19 February 2020 and notifications of the MNRE and Ministry of Shipping and canvass its application in trade and industry contracts as well. Now, I would, there is a good deal of literature available. For instance, under the wartime legislations in England and also in USA, we have any number of cases dealt with what exactly would constitute frustration, whether there can be a temporary suspension of a contract, and so on and so forth. All these issues have come before courts and before national governments, particularly during war times and even non-war periods. We'll also be looking into some of them to give some answers, some questions which have been put on before me. So let me now proceed to request Justice Ahmed to enlighten us on this subject.
Thank you, Mr. Venkatramani. I think you've covered the broad basics and general outline. We are faced with a very novel situation. The virus is also called novel coronavirus. And it is not so much the disease that is causing the problems that you have to consider today, but the effect of the disease and the effect of the lockdown and other measures taken in order to perhaps try to contain the disease, spread of the disease, and to eliminate it. The problem that we are facing is compounded by the fact that India is by and large constituted of people who are generally poor. And as a result of which, a lot of people are going to lose their livelihoods, and particularly the MSME sector is going to be hit very badly. Perhaps the larger corporations may be able to tide over this crisis, but I think that the industry at large, that backbone of industry and trade and commerce, has been hit very badly. There may be a few sectors like pharma or packaging or now alcohol, which might do well, but the other sectors would be in great difficulty. The questions that have been raised and which we require to consider, not necessarily answer, because the answers will come, according to me, from the courts. And we need to think out of the box and understand what is at stake. First of all, one of the prime questions is the lockdown constitutionally valid? Now, as Mr. Venkatramani pointed out, that the lockdown per se may be covered under the Disaster Management Act as a containment measure and itself being a measure of mitigation, because when you put in a situation of a lockdown, you are trying to reduce the risk of the spread of the disease, and that is a mitigating factor. Now, mitigation, I will come to that a little later. The word mitigation has to be construed in the context in which it is used in the Act. It cannot be expanded beyond that. But coming back to the Constitution, Article 19 of the Constitution, and particularly certain parts of it, provide as a fundamental right that anybody can move freely within the territory of India, and anybody can reside wherever he wants to reside. Now, if we see in the present scenario, both these rights are being curtailed. People are not allowed to move freely. You cannot move out of your house. A workman cannot go to their home and reside at their home places. So there is a curtailment of this fundamental right. Now the question is that Article 19 itself, within the article, provides for reasonable restrictions. Now, what can be the reasonable restrictions on the exercise of this right of a lockdown is to be gauged by what is the public interest, what is the larger public interest involved in this. Now, that is something which is very tricky, as Mr. Venkatramani would know. Whether a restriction is reasonable or not reasonable will have to be tested ultimately in the anvil of the courts. and arguments will be given on both sides that this lockdown was totally unreasonable. And on the other hand, the argument would be that the lockdown was necessary and it was definitely reasonable. So the question is that we have to deal with the situation that ultimately it is the courts which will decide. Now, coming to the other issues, whether the government had the power for compulsory payment of wages under the Epidemics Act, which is one of the issues which has been raised here. The Epidemics Act is of 1897. It is comprises of 4 sections. Initially, it was introduced to deal with the bubonic plague, and after the 1918 Spanish flu incident, another section was added to avoid territorial or let us say to avoid movement across countries, and particularly through naval ships. That act does not provide for any compulsory payment of wages or anything of that kind. So I don't see how the government can use that act for compulsory payment of wages. The question of force majeure is also an issue which will definitely come into the fore both in litigation in courts and in arbitrations. And force majeure essentially, if a situation of force majeure arises, essentially renders the contract void, and the promisee or promiser does not have to perform his part of the contract. Now, the other issue is, which Mr. Venkatramani also pointed out, that instead of voiding a contract, there could be a way out by looking at suspension of contracts. And what would be the effect of suspension? Who is to be compensated and to what extent? These are all issues which will have to be dealt with in the future, in the present and the future. Because what has happened in the course of this pandemic is quite unprecedented. There are, of course, other issues which I'm just reading those issues. For example, it says whether executive advisories issued by the state without direct reference to the Disaster Management Act or the Epidemic Act are enforceable. By the very nature that they are advisories, they are not legally enforceable insofar as I'm concerned. And even the actions taken under the Disaster Management Act and the Epidemics Act, which may be ostensibly under those acts, may be ultra vires those acts themselves. Ultra vires basically means that it is beyond the scope of the act itself, apart from the issue of constitutionality. So all these issues, I think, will have to be considered from a very, let us say, out of the box thinking, manner of out of the box thinking, because we are faced with new issues, and new legal principles will perhaps emerge out of this. But at the same time, the industry has to grapple with these problems. And I think I need not say too much at this stage. Maybe later on when specific questions are put, we can deal with them. So I think with this, I hand it over to the organizers.
Yeah, Manish, I think we are warming up to the hot topics. So I'll pass it back to you.
So from the good morning to we are about to transcend into good afternoon. And this is the period which is there. And if you look at it from now, coronavirus or COVID, as we understand, may be new to our generation and new to the world at the moment. But insofar as pandemics are concerned or epidemics are concerned, they are as old as the human history. So the oldest pandemic which I could, or epidemic which I could find out was again in China some 5,000 years ago. Thereafter, we have had many, and even if you look at, I was also looking at the manner in which it has been dealt with in the past. And I was also looking at even the last speech of the finance minister had used one of the quotes from Tarruvar, and where there also it had said that it is one of the prime objectives of the state to keep its citizens free from epidemics. Chanakya also prescribed certain prescriptions, and when we look at the directions which have been passed under the Disaster Management Act, they are quite similar to what they were. So therefore, if you look at in the 123 years ago, the British brought in the Epidemic Act. And if you look at this Epidemic Act was also, it was more directed towards the protection of their interest rather than the interest of the subjects which were India. And 124 years ago from Bombay, where my friend Ashish is from today, that is where they came out. And I was also looking at the legislative history, and a very profound statement when this was this bill was introduced. It said, while introducing the Epidemic Disease Bill in the Council of Governor General of India in Calcutta for better prevention of the spread of the dangerous epidemic disease, John Woodburn, the council member, while introducing it himself, considered the powers mentioned under it as extraordinary but necessary. Woodruff himself emphasized that the people must trust the discretion of the executive in grave and critical circumstances. So therefore, while we are speaking today, when the lockdown was first introduced, the number of people who were infected today are the number of people who are getting added in New Delhi alone. So therefore, today, while we speak, around about 56,000 people have been infected, 1,886 have died, and 16,500 have recovered. So there has been a constant duel between life and livelihood, and the government has been taking certain actions insofar as the Disaster Management Act, and most draconian being the Section 10. But in emergency circumstances, the notifications which have been issued and the manner in which the constitutional validity of the same will be looked after subsequently, maybe these matters will go into the cold storage and they will be heard in their turn. By that time, hopefully the pandemic would have come to an end. So the question is, they had this Disaster Management Act, which was also a creature of another great calamity, which was the Latur earthquake, after which we came into act, and the legislature in its wisdom thought that it is the Pandemic Act may not be good enough to take care of the situations. But today the situation which has been thrown up by this coronavirus has produced many situations, and force majeure, that is the topic which I've been requested by Alok to cover, has become very important. This word is now being used every day in and day out, and nobody in commerce, industry, or normal life is today unaware of this fact. Unfortunately or fortunately, Indian law does not recognize it as a concept. If you look at it as a concept, yes, but as a word, force majeure is not there in the Indian Contract Act. The manner in which our Contract Act has been so worded, 56 only provides you, as Justice Ahmed and Venkatramani have said, the standard under the Indian Contract Act is so high that most of the cases you can only avoidable, it will not get suspended. Probably this is one of the lacunas which is there, and one of the questions which keep on arises: what will happen to the leases? The law on the leases, one will have to look at the Contract Act, and one will have to look at the notifications, and nobody is saying that insofar as this pandemic is concerned, is not a force majeure event. But that is not about it all. If it is a force majeure event, whether or not you will be able to take the benefit of this force majeure event, or get the relaxation, or get the suspension of your rents or leases and things of that nature, will essentially depend upon the contractual arrangement between the parties. So therefore, if there is no clause in the agreement in that kind of a situation, I think you can only terminate the contracts if the situation becomes such, but there would be no suspension. But if you are lucky enough and you have provided some kind of a force majeure event and it has been named event in the contract, but it only talks about abatement of rent in a situation in most of the rental agreements. And if you look at it, it will be only in case of a destruction of the property or part of the property. If the property is intact, then no such benefit would be granted, and as such you will be left to your own fend yourself, not outside the contract. And it is not that what will get suspended and what will not. Even the Contract Act does not take into account a situation if the situation was there for a 6-month period or something. Unfortunately, even the insurance laws do not take care of. They will also provide you some kind of a succor only if there is a destruction of property and not in epidemics. And most of the insurance clauses, there would be a specific exclusion insofar as such a situation is concerned. So therefore, getting benefit is very difficult. Insofar as these legislations are concerned, the 20th March notification or the 29th March, if you look at it, those who have created that you have to pay, fortunately or unfortunately, the matter went before the court. The court did not grant the interim relief. And insofar as the this act is concerned, it says that you will be met with a penal action. So therefore, there is a balance which needs to be created between life and livelihood. And then ultimately, I think with the passage of time, these orders will be modified. The government will take into consideration. It has to take into account the most vulnerable section, and at the same time MSME and also the businessmen, as a result of which the economy should not come to a standstill. Many legislations in countries like Singapore, in London, in UK, they have come up with Pandemic Act. In UK, 2020 Act is there. It deals with the situation insofar as leases are concerned. Certain other moratoriums have been granted. So this is an extraordinary situation, and it will require extraordinary solutions. We may not be able to look at the rear view mirror and continue to do what we have been doing in the past. We will have to look the entire situation afresh. New jurisprudence, new judicial pronouncements will come. All those 4 judgments which Mr. Venkatramani has mentioned may have a relook at it. The judges may find out ways and means in order to provide justice. In arbitration, I'm not sure how it'll happen. One will have to remain within the confines of the contract between the parties. How the civil courts are going to read, maybe there is going to be a judgment, maybe there is going to be an amendment in the law. But till such time, there is such, insofar as leases are concerned, fortunately or unfortunately, no benefit is going to be available to most of the people unless they fall into the rarest of the rare case and they had the hindsight of benefit of foresight, if you look at it, and the manner in which they would have had clauses in that contracts. But unfortunately, that is going to be for a very few and very difficult. And over a period of time, I see the notifications would come. The government would look at the situation in a more holistic manner. My friends Meenu and Ashish, being in the IT industry, will continue to do well. That is provided the backbone. Liquor, as Judge Sabet said, 6,000 crores is all that what liquor contributes in Delhi. And we had communal allegations for 3,000 people going there at a particular place, and we have 3,000 people standing outside at least 1,000 shops. I do not know what has happened. And if you look at it, the government, I was looking at the budget of the Delhi government itself. Out of the 50,000 crores, 14% of the revenue just comes from sale of liquor. There is no sales tax which is there. There is no GST which is coming. There is no great revenue around about for stamp duty which is coming. So probably between life and livelihood, the government also got stuck, and they said that it may be a good time to recover those kinds of money. I think these are difficult times. There'll be hit and trial. 100 years ago, maybe the Spanish flu, we did some things. We were under the colonial masters. Now the requirements have changed. The judiciary has stepped in under 141. They have provided all the succor. All limitations have been increased. All interim orders have been there. Rarest of the rare cases are being heard. Now rare cases are being heard. Immediate cases are being heard. And once life becomes normal, maybe all arbitrations and courts will open. and we will probably have to learn how to live with this virus until and unless we have a remedy, medicine, blessings from the Almighty, or a vaccine. We'll have to wait till then. Over to Alok.
Thank you, Manish. Thanks, Sophie. Just so that we have a bit of an interactive session, Your Lordship, if I may just, before going to Ashish Chandra, there's a very specific question for Justice B.D. Ahmed from Kalindi Mehta from SAP. She has said that there is a reference to penal provisions under the Act, especially the penal provisions of section 51 to 60 in all the notifications, which are issued in addition to reference to section 188 of IPC. In terms of corporate liability, if all reasonable precautions are taken and there is compliance to the standard operating procedure, what is the liability of a corporate in such situation?
First of all, there are two aspects to it. The first aspect is whether the direction or the guideline or the instruction given under the Disaster Management Act is intra-virus the Act or ultra-virus the Act. That is one of the issues. Suppose there is a direction given ostensibly under the Act, but which does not fall within the domain of the provisions of the Act and goes far beyond it and impinges upon constitutional rights. Will that be will a violation of that be held to be penal? That is one issue. Now, these are all tricky questions, and on a case-to-case basis, they will have to be examined. And if somebody feels that what he is doing is not against the law, but there is a direction or a notification which asks him to do that thing, to not do that thing, then his only recourse is to go to a court of law, because he has to follow the legal system. I am a great votary for the judicial system. One has to, whatever grievance you have to take it to a court of law. But what is happening today is, unfortunately, that the courts have also not been functioning at full steam because of this pandemic. And I hope that the Chief Justice of India and the Chief Justices of the various high courts ensure that each and every court functions fully to its full capacity as early as possible. Unfortunately, we have been caught on the wrong foot insofar as the technological advancement in the judiciary is concerned. Had we adopted e-court system throughout in the comprehensive manner, then we wouldn't have faced this problem. The problem today is that the judges are available, they are ready to work, they want to work. What is holding them back is the technology which is not available to them. And unless and until we, in the shortest possible time, solve this problem, you won't have courts functioning in full strength. And unless and until that happens, what Mr. Lamba pointed out, that people went to the court, fortunately or unfortunately, no interim order was passed, whichever way you look at it. The question is, if all courts were functioning, then some court or the other would have passed some order, and that would have been taken maybe to the Supreme Court and debated in full. Now the question is that unless and until the courts are functioning, there is a rationing of cases, and some courts are just functioning on 2 benches or 3 benches, whereas other courts are functioning with 5 or 6 benches. That is not good enough. And the backbone of the thing is the district judiciary. They are not functioning. So these are issues which have to be sorted out by the legal system, by the courts. And I think, according to me, the first and foremost thing for any government or the judiciary is to put back the courts in full swing. Unless that happens, where will the individual go for the redressal of his grievance? Where will, say, a person who owns a factory and has such issues which come up before him, whether he has to pay wages, he doesn't have to pay wages, does he throw out the people, doesn't he throw out the people, does he have to retain even if he is incurring losses, etc., etc. These questions will have to be tested and answered in the courts.
Right, sir. Yeah, Ashish, I think you can now take over.
Yeah,
The
I think
new age technology person.
this is a very good segue, and I think the stage has been set by Honorable Justice Ahmed for me to just jump in and talk about technology. But I think at the outset, I want to thank all the panelists. I know it's a very valuable Saturday where you have to spend some time, extra time with your family, uh, and not doing the work. So thank you, panelists, and thank you, attendees, for your time. I think I would actually focus mainly on how internet technologies or internet products are actually seen or can actually contribute to the new world which we are now entering into. As you know, you all may have seen that this is a watershed movement for the humanity, for the whole world, wherein everybody, whether you as an individual, or whether you as a judge, or whether you as a lawyer, or whether you as a business person, has to completely relook the way you want to conduct your life and business and activities, like you were conducting before March 2020. And this is a watershed movement also for the internet industry. As I mean, you may have seen not only from the increase, I mean, usability of all internet platform for everything, whether it is for your entertainment, whether it is for seeking of justice, whether it is for communicating with your friends and family, whether it is for buying some essential product, whether it is for education, whether it is for health, so on and so forth. And this is not something which is people are talking about. In fact, if you see in the Wall Street, you could see that what kind of optimism and what kind of bets people have now started to place on the companies which are in the forefront of internet technology, testified by unprecedented growth in the stock price of various large internet companies. And they are actually, in these times, they are trading at their uh, lifetime high. So while my other co-panelists will focus more on how to solve the recent challenges under the Disaster Management Act and various notifications issued under the law, I thought that it may be opportunity for me to share my thought process, where I see that what are the various novel internet business models are being created, and what is the present your legal ecosystem to support those, and where all I think government can intervene and can ensure that the legal ecosystem continues to support the growth of these technologies. Now, I think the most important thing as of now, which we are seeing, is that uh, 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 your abundant and cheap availability of internet, which is your basic broadband. I think we all have to thank the efforts which have been taken by our government, and also various interventions which have come from the court, which has ensured that internet remains equally available and at a very, very affordable price to everybody in India, irrespective whether you are staying in a South Bombay or a South Delhi, or you are staying in a southern, let's say, village of India. Everybody has an equal and robust access to internet to ensure that they I mean, continue to communicate with their friends and family, and also get entertained. Similarly, I think it is not only for the people, but also for the businesses. I mean, today we are talking on Zoom. We buy things on various e-commerce websites. We extensively use WhatsApp and Facebook, other activities. Now imagine that if let's say the law is not robust, uh, and let's say government and courts allow to interfere in a business's right to use internet to promote the businesses, we would not have seen the benefit what we are seeing right now. So I think we are blessed to live in a country where I think these things are being held to be the basic fundamental right to have internet, right to do business on internet. I know there have been a recent Supreme Court judgment, but I'm just talking about the spirit of the law, and it may have some nuance from one state to the another state, depending upon the national security issues and all. And also, if you see the TRAI regulations, they also are promoting the net neutrality. It's not that this is a stage where all the internet companies are very, very highly valued by everybody. They want internet to be unfetteredly available to India. And I'm very pleased to see that no technology company or a telecom company is trying to take undue advantage of, promoting some of the private interest in that. So I think thanks to our robust net neutrality guidelines and the TRAI, that we have equal access to any technology or any internet application which we want to use in our daily life. Looking at what kind of new business models which we are using it on a daily basis, I think the most important part is the communication apps, whether it's Zoom, whether it is Facebook, WhatsApp, Twitter, LinkedIn, Blue Jeans, anything, I think whether they are Indian products or they are external product, outside India product, I think they are the one, these are the new business models which we are using to ensure that our life continues to remain, normal in these tough times. Similarly, those who have children who are going to school and colleges, these technologies are helping them to continue with their education. And I think I can testify about my son. I have a 13-year-old boy. I think the way he enjoys doing his online classes at the comfort of his home, where both me and my wife can also spend time and help him understand what's going on in the class. I think these are the new things which we are seeing. Now, we also talk about e-codes. We talk about e-health. And I think the government is also intervening to ensure that they make the right kind of ecosystem to promote all these businesses. For example, very recently, guidelines have been published on e-health. Now talk about e-commerce. Although e-commerce is not new in India, but the Indian government has ensured that there is a equal opportunity of doing trade available both to online commerce as well as offline commerce. They have ensured that if in the offline trading industry, only the essential goods can be bought on the physical store, they have ensured that they are not discriminating with all the mom and pop shop owners, have ensured the e-commerce entities are also only allowed to sell the essential commodities. You look at startup schemes, government is also promoting various schemes to support the startups who are facing some funding crunch. So I think the entire ecosystem is also being developed, and and also if you see what the Indian government has done, both the central government and the state government, their adoption of these technologies, let's say they have their own verified accounts on Facebook and Twitter and LinkedIn and WhatsApp and all, to ensure that if any of the citizen wants to have authentic information on what's happening on COVID and other aspects of the government functionary, they are not stuck with any fake news or an unverified news. They have all the choice to go and interact with the verified handle of the government agency and get the first-hand information from the government. And last but not the least, I think this is a time where government also need to relook at most of the cyber and the IT laws, which they have passed in early 2000, and they have made very few amendments here and there, essentially in terms of electronic signing of the contracts. I think the law is there, but I think it need to be beefed up to fit for the purpose in the current realities. Do we need to really relook at the Evidence Act in terms of the presumption and onus of proof of electronic signing of the contracts? Do we need to revisit our laws in terms of the data privacy and data protection? Do we need to further strengthen our laws on encryption? I mean, nowadays courts are all on the encrypted platform. I mean, we do have some good laws under IT Act for encryption, but we need to do more to ensure that the encryption actually becomes the way of life, because everything is now being talked and done through the encrypted platform. So I think we are almost there to take advantage as a country and as a legal system in the new world, where more and more things will happen online, and including to the point which was made by Justice Ahmed and also Manish Lamba, that it will impact the mom and pop shop and the SMEs. The answer is no, sir. I personally don't feel that this will impact them. I think everybody have to relook the way they have to do their business, and everybody have to get educated and aware about the online tools which are available for them to promote the business. And I know personally those people who are smart enough, who have done the early adoption of some new technology, they are back in business. They are earning now more, in the sense their revenue may not be as compared to what it was in the month of Jan and Feb, but their bottom line, their profits are more than what they used to earn in Jan and Feb, because the online tools are very cheaply available, and the capex which they need to invest in the business can be reduced. So it's a time for people to really rethink how internet and internet technologies can really help us as a nation, us as human, us as the business entity to really go and thrive in the new world. And I think the laws are there. We just need to relook and make them fit for the purpose for the new world. Thanks, Alok.
Somya, I think you're in a mood.
Ashish,
Yeah.
there's a question which I think you might want to answer. It's by Somya Banerjee, and it is, what is the constitutional validity of compulsory downloading of the Arogya Setu app? Because I think there's a lot of issues around with respect to the privacy and data collection.
Yeah, it's a good question. I would defer it to my friends who are in legal practice and to Justice Ahmed to answer that. I personally don't want to take up this issue and answer about it.
Right. Thank you, sir. Justice Ahmed, if you would like to answer this question.
See, there are various sections have raised serious privacy concerns, and I think those privacy concerns have to be met. And the other aspect is that there is no legislation to back this application. It would have been better if the government had come out with a legislation and provided the backbone for such an application. There is also no tenure of the application, in the sense that how long would the data that is gathered by it be utilized or kept, and for what purposes. So these are the issues which are concerning the people, and that is why huge number of privacy concerns are being raised, not only by lay persons but also by people within the legal field. And I think the order of the day is that the government should be more transparent about it and come out with its exact policy as to what it wants to do with this application. Because there might be other concerns. For example, why should another person know whether I'm suffering from a particular disease or not? Why should my neighbor know whether I'm suffering from a kidney problem? Because these are part of the Hippocratic oath that the doctors take, that they are in fact, under the Evidence Act, they are protected from not disclosing the ailment of their patients. So all these concerns are there, and I think the main thing is that it is for the government to come out into the open and lay bare as to what exactly is the context of this application, what is the extent of this application, and what is the tenure of this application. Once that is clear, then it will have a much wider acceptability, and the various concerns that people have would be addressed. I think there is also a requirement that many of the people feel, particularly in the IT field, IT technology field, that there is no harm in revealing the source code of this application also. Because if the source code is revealed, then it makes it absolutely clear as to what is in store or what is in stake. I think that should answer the question.
I think I was just reading the historic perspective, just to add, of the Epidemic Act when the British introduced it, and at the same time there were issues like privacy which were raised even 100 years ago, and the issues which were raised were: how could you put Hindus and Muslims together? How could you segregate women? How could you check them physically? How could a surgeon check these women? And probably one of the freedom fighters also raised a very serious concern about it. And there is a book also written insofar as by a lady, and which says it goes by the name. It goes by the name Charu Gupta, in her insightful work, Sexuality, Obscenity and Community, she writes about this plague. So I think concerns about privacy are very well valid, but I think if a choice is to be made between privacy and life, we all should know what will prevail. But whatever can be done by the government should be done. They must come out with whatever transparency is required. But if this one app is going to save many, so it be.
I think the only thing which I would add here is that I think there is no objection in making it mandatory for the people to download in the containment zone, because that's for the benefit of others. I know people may have their own question on the privacy. The only thing which concern to me as an individual, as a citizen, is that everything, okay, whatever is being legislated is followed by an imprisonment. If you do not download the app, you are in jail for 6 months.
That is certainly bad.
Which we have seen that, okay, even if you see the IT privacy rule, even if you see the PDP bill of 2019, they in fact don't even talk about imprisonment. In fact, in the PDP bill, only if you have reverse engineered the unanonymized data to come to the personal data, there you have an element of imprisonment. Otherwise, there is no element of imprisonment even in the PDP bill. I think that's something which really scares the people. You can put some other punishment, some sort of monetary penalty, some other restraints, but if not downloading the app, if I go to the jail for 6 months, everything,
no, you should
the whole
not.
of India will be in the jail for I don't know how many.
Certainly. During the plague time, they had come out with a ticket, the railway ticket, when plague was in the colonial era. They used to punch it 3 times. And people took such objection to it that nobody would sit along with them. So then they had to withdraw this. So I do think the colonial masters also changed. The present government is our own. They would certainly change. And all these fears and all things needs to be addressed. So once they are addressed.
Alok, just to add on, I think these views are absolutely well taken, each one of them. And we are looking at a fine balance that could have been drawn by the government, either by going through a legislative process. Now, today, government is drawing heavily on its executive power. And, this executive power cannot be so overloaded. And then completely closing your eyes to a variety of rights concerns. And even the data protection bill, we have a data protection obligation. There has to be a purpose limitation. There will be a collection limitation. There will be a lawful processing. There are lots of limitations thought of carefully into that bill. With one swing, you say, look here, you will be liable to be prosecuted. And places a lot of unlimited, unbridled power in the hands of a local investigating, prosecuting agency. And this is a too much thing to be taken care of. Yes.
Yeah.
So if I may put a question to Venkatramani sir. So what is the test of reasonableness in the DM Act, the impositions laid down in the DM Act? Are they reasonable, unreasonable? And to what extent did the government impose these restrictions?
Who is it addressed to, this question?
Venkatramani sir.
Venkatramani.
The test of reasonableness.
Yes, sir.
About this, what?
The
about
Disaster
what?
Management Act, sir. The impositions.
See, if you are looking at the act per se, then it will clearly pass the test of reasonableness. Nobody can say a disaster management is outside the competence of any legislature or parliament or the state legislature.
Right, sir.
The question is not about whether legislature per se is constitutional, but whether what the government is trying to do by invoking one or other provision of the act is a question for consideration. Therefore, the law per se is not unconstitutional because it doesn't violate anybody's rights. If it is in the interest of general public, Article 19 rights can be certainly subject to reasonable restrictions. So with both the freedom to move and the freedom to carry on trade and profession, in the interest of general public are restrictions available to Article 19, 5 and 6. But if you are talking about the invocation of any particular provision as if it is a fit for all size kind of a legislation, I think there the problem lies. I don't think the Disaster Management Act was conceived, intended, and with sufficient safeguards and comprehension of a wide range of consequences that will emerge if you are to impose, let us say, a containment measure, a mitigation measure, even a relief and a rehabilitation measure. So if the disaster concept of disaster was to address, for instance, the well-known sense of assurance of disaster, but if you're now talking about a common economic disability, so if you're talking about an economic disability imposed by reason of some other mitigation measure under the law. So if the economic disability is a consequence, and people have to find ways and means as to maneuver through the economic disability, I find that the Disaster Management Act does not provide any clear solution. But if you keep on invoking it more and more, there could be serious problems. Manish referred to the attempts made by England and Singapore. And for instance, in 1943-46, they had this frustration of contracts legislations. But they were all legislation to address the English law, which is like gathering the whole English law and putting it into a statutory form. And if you look at the recent attempt, the Coronavirus Act in England or the Singapore legislations, they are all again attempts to look at the consequences of a lockdown. So therefore, probably one may need to think of a wide range of issues arising out of a lockdown and look at a national economic disaster management plan. So national economic reconstruction plan, national economic reconstruction aid and advice. We'll have to look at all those issues from an entirely different angle. You may also, innovate new terms, nothing like a frustration. We talk about quasi-frustration. We talk, we may create new concepts, but I don't think there's room for all that under the Disaster Management Act.
Thank you, sir.
Yeah, me.
Meenu ma'am, over to you now.
Right. Thank you. I hope I'm audible. So good afternoon, Honorable Justice Ahmed and my co-panelists. Thank you for giving me this privilege to join all of you. And I'm going to sort of bring this all together because we've heard a lot of aspects around the constitutionality, the legality of the actions of the government, and then, how technology is playing a role in there. And when I look at it from my own industry's point of view, so I look after a portfolio which ranges from issues on Special Economic Zone Act compliances, which means, how do we comply with what is coming in as guidelines from an SEZ perspective, what is coming in as guidelines right now from a labor law perspective, from a Shop and Establishment Act perspective. So I'm grappling right now with all those ground legalities in the context of what those particular guidelines are asking industry to do. And the industry that I obviously represent is the services industry to a large extent, along with IT products as well. And when we started seeing in January itself, COVID coming in, our disaster management internally, which is called the BCP, business continuity, we went into action pretty quickly in terms of our business continuity, like any other organization must have. And as a result, we saw that the government itself in India, we feel, and I personally think that we went very quickly in understanding how do we mitigate, as we are all talking about this disaster being in the context of mitigation by containing, right? And in that containment, the government came out with some very quick steps in terms of saying, all industries are encouraged to work from home. Obviously, it doesn't work for all the industries. It only works for IT-enabled industries or industries which are more in the services sector than in the manufacturing sector. And as a result, we were able to move very quickly in 3 weeks' time, I would say, to a work from home strategy. But that doesn't simplify stuff for even an IT-enabled services industry. For example, you would not be able to have a fully working workforce from home until all of them have laptops. And obviously there's a differentiation of functions and skills where people are having those gadgets. So we had to really move very fast with all those. But I'm very happy to say that even in those contexts, the government functionaries, the government authorities who were supposed to approve movements, especially because we are mostly in a special economic zone and we are like in a bonded and a custom bonded area, we had a lot of cooperation from the government agencies, whether it's the district magistrate or the SEZ Development Commissioner to move things quickly. So from that point of view, I think that the government was doing the right thing at the right time by facilitating businesses who needed to be continuous in their work functions and to deliver whatever their services were. And of course, the manufacturing has a different element, and I think others have touched a lot more on how it's impacting the society and the supply chain. But the guidelines, because they are really broad, they talk about everybody the same. And as we heard, it's not a one-size-fits scenario. So while a company like ours was able to move quickly to a 95% work from home scenario, what may not happen for the SMEs? And we are obviously having vendors in the supply chain. So if I want a laptop, I'm not getting it because of the supply chain issue, right? And the same things as security guards, facility management services, and all the ancillary associated services that you need to run a business, that is getting impacted. And then the guidelines are also not very clear. And as my other co-panelists talked about it, how much of these advisories are mandatory or legal or within the parameters of the law for us as an industry to follow? While the vendors would ask, hey, you have taken X amount of workforce from me, you can't reduce it. Or they will try to read the advisories into the contracts while they might not be applicable. So there's a lot of gray area there, which all of us will see panning out, whether through litigation or mediation and stuff like that. But at the same time, what I'm also grappling with on the ground, and I can share, is the fact that when you are across the country in different states, and for us, we are also outside of India in various countries, and we do run the global compliance from India, tracking those advisories, of course, and then interpreting and getting into the nuances are pretty tricky. So, there's a lot of work obviously generated for lawyers all across for that point of view. But within India, I'll just focus on India because we are talking about India here. When I look at the states that we are in, Uttar Pradesh, Telangana, Andhra Pradesh, Tamil Nadu, Maharashtra, and to some extent in West Bengal, I'm looking at various ways of interpreting requirements, states coming on different footings, while they are saying, yes, you can have 33% workforce coming in. However, we are in a containment zone because it's a red zone. So even if there were relaxations given of 33% workforce coming in, the moment you are in a red zone or a containment zone, whichever way you want to see it, you're really not going to be able to do much about it. So all those, vagueness and the central saying one thing and the state interpreting it, or even taking a harder line than the central because they are more tasked with the ground realities, is making difficult work from an interpretation point of view, and also from a point of view of how do we really comply with the law or the advisories every other day that we are getting in. The only thing which is, I think, constant, which is good, is that there is a clear-cut guideline of how the SOPs are going to follow, what would be the social distancing requirements, what would be the health and safety requirements, and how are we going to look at the new normal in terms of getting back to work, as we are calling it. How do we really get back to work? And I'll also sort of share how we think that the new normal is. It is clearly going to be a case of a high level of productivity from work from home, where we are looking at, and we've already leveraged Cisco WebEx and Microsoft Teams, which are sort of more corporately used web portal, web conferencing facilities. And I think because I'm also a person who's looked after cybersecurity in my past roles, I feel that it is very important, whether it is an individual or an entity, an organization looking to adapt to the new normal, to think about their security and privacy and making sure they're on the right kind of security settings. It can be any platforms, but on the right kind of security settings and the aspects related to that. And I think India is already on that journey, which is the Digital India, which was already launched way back. And they have taken big leaps. And, We talked about the judiciary, and I'm privy to some of that work because I happen to have a spouse who's also a lawyer. There's a lot of work that is going on at the judiciary level, which may not have been publicly sort of talked about. But the Supreme Court is already in touch with various technology platforms to quickly get on top. And I've had the privilege of working with Justice Pratibha Singh in my Microsoft role, where we were talking to them about how to digitize the whole of High Court. So I think they're already on the journey, but we are right that we are a little bit on the back foot in the judicial scenario where we could have done it earlier, but it's never too late. That's how I feel. Moving on to other really looking forward challenges, I think it's going to be the biggest challenge, as already been said, is that how do we really think about the economy in the context of ramping up back? And a lot of that is to do with consumption. And I think, Ashish can of course validate that, but e-commerce is not able to leverage itself to the extent of doing non-essential goods. And that brings us to the point is what is essential and what is non-essential? Is it only the essentials within the Essential Commodities Act? And of course, there's a clarification that even IT services are essential, telecom is essential. So there has to be a thought through, strategy for bringing the economy back in its, rhythm. Because even I need an iPhone and I can't order a laptop for my children because everybody's doing classes online and we don't have enough gadgets at home. So I think we have to relook at all the categories of what is being, classified as essential, as a non-essential. And today in the news itself, there was a discussion which was talking about by 15 July, we should have a negative list of prohibitions rather than a positive list of what can be done. And I think that's a good way to look at it as to what is it that really we need to keep closed down rather than closing everything that's happening. I'm happy to take any questions. That's it for now.
So Meenu, on the question of the e-commerce, I think again, it's not about opening things for e-commerce company to deliver to you because that will keep you safe. Let's say an iPhone, but I think the issue is more about how can it be non-discriminatory. You are asking your neighborhood shop to be closed so they would not earn revenue from you, but e-commerce companies will earn. I think that is the question which I believe government is grappling with for giving more relaxation to the e-commerce companies than anything else.
Yeah, and that's a fair point. The only concern I have is the mom and pop shops are now opening up, right? Especially within the colonies, it is no longer a non-essential and an essential category. So within my condominium, I can get stationery and pens and whatever, even if they're not essential. Although I think they're essential from a different point of view, right? So yeah, you're right. Obviously, that's also an important thing to look at. How can we be fair to all traders, whether on the e-commerce platform or as a brick and mortar?
If I may just request, this is BD Ahmed sir, that with the issues which have been raised by Meenu from an IT industry perspective, is there some input which you'd like to suggest or a guidance for the industry?
On information technology?
Yes, sir. She raised a lot of issues about vendors, about demand from the vendors. Like for example, there are customers, say, of IT company who say because of data privacy, etc., we will not allow you to work from home. I'm just giving you as an example. So considering the vast areas which Meenu had dealt with relating to IT industries, what would be your suggestion as a judge for that?
See, insofar as working from home is concerned, I think this was a concept which had started in the West much earlier. I mean, a lot of companies were working from home. I mean, to a large extent, up to 50%, 60% of their workforce was working from home. The requirement of security is not necessarily broken by working from home if you follow the correct protocols. I mean, the technology people are there. If you have the correct protocols, it's not necessary that the security aspect will be broken. But the issue is different in the sense that it's between the vendor and the buyer, and they have to come to a mutual understanding. And Meenu mentioned a very important thing, that it's not just the courts, but things can be sorted out through mediation. And mediation is one aspect which does not require that kind of technology that you require for a full-fledged court. So if while the courts are not able to come up to the technological state in which all courts can function virtually, mediation can be adopted by private parties. What prevents them? Nothing prevents them. In fact, they can have the services of a mediator, or even if they don't have any mediator, they can try to reconcile issues amongst themselves. And
Right, sir.
there is no restriction on private parties in respect of their private contracts between the two of them sitting down together and discussing and sorting out issues. That avenue should be, I think, in the present context, I think this is a very important thing. They should sit down with each other and maybe through video conferencing or whatever it is, try to sort out the issues that are confronting both of them. And I'm sure both will be reasonable in this backdrop.
Alok,
Yes,
just
sir.
to add to it, I think we have this free litigation, mediation, and a commercial courts act in any case.
Yes, sir.
Now, ultimately, in the light of all these issues, one bottom line is industry and trade has to take a commercial call and say what will be good, better, fair, just, right? All those terms understood properly. So you take a commercial call finally. So in order to do that, instead of probably getting into serious legal questions whether a particular act will be read, strictly or widely, favorably, all those things will certainly happen in due course of time. But if you have this kind of a model available in a law, and if it is trade and industry are free to now start engaging themselves on this pre-litigation mediation where no holds barred. So for the arbitration, unless the arbitrator is conferred an authority to act as a mediator, the arbitrator is in certain difficulties and constraints. So I think
Right.
it can overcome all that by evolving a formula where if one industry sets an example, the others can follow suit.
Right, sir. So, sir, since we have about 15 odd minutes left, though we have been asking question answers in between, broadly there are two areas of questions which is still pending to be answered. Somya, perhaps first question on employment, you can raise it Mr. Venkatramani for BD Ahmed, and about the property all related, Manish Lamba sir will be able to better answer that.
So, Venkatramani sir, this question is for you. So, first is the NDM Act empowered to pass orders overruling the provisions of the labor laws and employment laws? And also with respect to the latest, right, and also with respect to the recent relaxations in labor law by the UP government.
See, as I mentioned earlier, none of the provisions of the industrial laws directly deal with any consequences flowing from a situation like that. Orthodox concepts in ordinary times, such as layoff, retrenchment, closure, operate in entirely different circumstances. Even if you stretch them, I think they'll break down when you try to apply them to a circumstance like this, number one. Number two, in none of those legislations, in none of these legislations, you will find a government getting an authority, stepping in and saying, I give you directions for your compliance. I think it doesn't happen like that. So all the authority assumed under the Disaster Management Act, or possibly under the understanding that the concept of mitigation, namely to mitigate the disaster, includes the capacity to do other mitigation measures flowing from the mitigation measure itself. So that's the understanding of the government. There are two mitigation aspects, the mitigation of the disaster and mitigation of the effects flowing from the lockdown. The government, then there's one understanding. Perhaps there is some seriously questionable understanding.
Sir, there are a lot of questions on property related. So this is something which I'm addressing to Manish Lamba and just BD Ahmed after. I will read one question which is very wide enough so you can narrow it down. It says, in case of lease, when the lessee is in possession of the premises and the lessor has performed its part of the lease in making available to the lessee the unusable premises, can a lessee still invoke force majeure clause on the basis of the COVID-19 and more importantly, the national lockdown to not pay rental and maintenance? How would reciprocal promises work in this context? And the follow-up is that can commercial leases be differentiated from simplicity leases insofar as post-COVID situation is concerned by the courts? So this is a very broad question, but Manish and BD Ahmed sir, Ahmed sir can address that. Manish, starting with you.
Okay. So insofar as the leases are concerned, the law is very simple that you'll have to look at the Transfer of Property Act. Lease finds reference under the Transfer of Property Act in Indian legislations. If you look at it, I have, as a lessor, I have already transferred the property to you. So it is not a executionary contract, it is an executed contract, and therefore, as a lessor, if I put a foot into your property once I have leased, I will become a trespasser, unless there is some provision under which for maintenance and all I may enter into the property. So this is one part. The other part is that if frustration or insofar as force majeure is concerned, you'll have to resort to 56. 56 does not provide you any kind of a temporary relief. It will render the matter void. Assuming that you have a shop or a huge big office and you have spent ₹1 crore rupees on it, and there is a rental of 2 lakh rupees a month, and you terminate and you send a notice, after it will also provide after 60 days, the lessor will have the right to terminate if the force majeure situation arises. So there are many practical difficulties. The lease would be for a period of 9 years. Insofar as this blip of 1 month, 2 months are concerned, if you are going to create those kind of issues, again, I will go back to it. It is very difficult, first of all, to prove that there is some kind of a force majeure. Even if it is there, you will only have the right to terminate the lease, but that may not solve your problem. If there is a business-like solution which is around, mediate, conciliate, talk to your landlord, understand the difficulty. If it can be sorted out, it can be sorted out. Otherwise, you can't live in the premises, continue to enjoy the premises. You had been in the occupation of the premises, except for damage to the properties. The classical lease clauses which have been drafted will not give you that kind of a reprieve. So therefore, please look into your clause. If the clause provides for this kind of a situation, good luck to you. If it does not, then resort to a business dialogue. That's all what I can suggest. You may not have many legal solutions to a problem of 1 month or 2 months of this nature. You may have a business solution. It may be a better thing to speak, find out a creative solution which is a win-win to all. That may be the only possibility. But if there is a clause which clearly categorically says that if there is a pandemic of such a nature, and not only that the premises is intact, I am unable to utilize it for XYZ purposes, in such an event I am not going to pay you rentals, then you have certainly gone to a very good lawyer and paid him much more than the rent. Good luck to you.
I would request also BD Ahmed sir to add to the lease and property law aspects.
Yeah. No, I agree with Manish in whatever he has said. You see, there are all leases are drafted rather shoddily these days. One comes across that. But as he pointed out, if you got good advice and you drafted, had a proper lease drawn up, then there may be clauses, both from the perspective of the landlord as well as from the perspective of the tenant, which may rope in a situation like the present one. It is quite unlikely, but there may be some clauses which may do that, in which case you can work within the lease. The other thing is, that in the present scenario, I don't think many landlords would like to let go of their tenants in the long run. So I think it would be advisable for tenants to talk to the landlords and maybe come for a deferment of lease or rent payment or a part payment of rent for this temporary period of 1 or 2 or 3 months and get over the situation rather than completely make the lease void and walk out of it.
So in fact, as an anecdote, me and Mr. Venkatramani sir were dealing with a matter in Supreme Court where the landlord had taken an injunction from the district court in Gurgaon that the tenant should not leave the premises.
That is the position these days. And real estate has taken a really big hit. Real estate is taking a really big hit. So,
Somya?
Yeah.
So the sum and substance is, unless you had a genius lawyer and you had the benefit of hindsight and a good foresight, and you have drafted a marvelous clause, good luck to you. You need not come to a chat and ask a question. Salute to you. But if it is not there, find a business solution.
I would probably say many of these queries, of course, are very adventurous in the sense of you want some answers which may please you, but they are hard reality. Therefore, you just can't get a quick answer and say, all right, I will not parent, I will discharge, terminate a lease.
But I will do some crystal grazing and what is going to happen. If you look at all the leases which were there, they provide for destruction of property or there is a damage to the property. Insurances were available and insurances covered the rental loss for that period. So one could not have had a double dip, take the rental from the lessee and also from it. I think 6 months from now, or 3 months from now, or 9 months from now, you will pay 10 paisa or 50 paisa per square feet extra, and an insurance company will make a business out of it. And these issues will not be there for the future lawyers. And for the 6 months, there would be litigations and things, or maybe some disputes will arise. But future, I think insurance companies will see a large business into it. This is a once in a 100-year event, and therefore insurance policies will not be very expensive. So I think
true. Risk management in insurance contracts is a special species of subjects for study. You know it.
Yes. So I think more answers will be found for future in the insurance policies. And I think some of the lessons learned from COVID will also be one of this.
There are two questions which I will have because we are just running out of time.
Alok sir, an important update. Alok sir, just 1 second. On the request of the attendees, since there are quite a few questions unaddressed. And
that's what I was coming to. Please.
We are increasing the webinar by 15 minutes, sir. So we will now conclude by 1:15.
Can we go to the question by Dr. Parikshit Sirohi and Professor Dadij one by one?
Sure. 1 second, sir. Dr. Parikshit Sirohi, can you please unmute yourself and ask your question?
Or you can go to Professor Dadij if you want.
Professor Dadij, can you please ask your question? Please unmute yourself and ask your question, sir.
Yeah, so hi, good afternoon. So my question is very simple. That what do you see the impact of this present situation on automation? Because automation is already happening in employment sector, and especially I'm talking about the labor industry instead of service sector. So in labor industry, already we have seen a very drastic wave of automation and unemployment. Obviously, that was an issue. But in the post-COVID situation, where companies will have more incentive to go for automation, so how do you see this situation in our present labor laws and regulation? How we can protect the interest of economy in terms of better automation, creating economic efficiency in market, at the same time protecting the basic human rights of labor?
I can talk about the automation first in the sense how it can be enabled, and then my co-panelists can talk about the human rights versus labor. So you're right, this is a watershed movement for all the businesses which are labor intensive to ensure their continuity, that all the robotics and AI techniques will be adopted. And I know that a lot of investments have been recently made in those technologies to ensure that the manufacturing units are not heavily dependent on the human beings. One small legal kind of development that has happened very recently in US and EU, when somebody was trying to obtain a patent which was invented not by a human being but by an AI. The US and the EU courts have held that the AI cannot have a characteristic of a natural person, and therefore, as per their law, the patent can be granted to a natural person, and then they rejected to issue patent to an AI. Now, how that jurisprudence of natural person being attributed to a robot and AI under the Indian labor law, can be addressed by my esteemed panelist.
I think just look quickly, two glances at this question. One is the first wave of automation when all the computing technology came in, and then we had a public sector, banks and government employees talking about automation and a huge layoff of the workforce. But then automation created a workforce by itself. So the technology in due course of time, depending upon how we profitably extend the potential of the technology and then bring in an element of literacy, along with that. I think that will be one way of looking at it. So there are no abstract answers to these questions. It all depends on how concrete technical measures we are able to take. So there, of course, the huge academic discourse on artificial intelligence and things like that. I don't think that's a thing which is confronting us today. But then we need to take a long look at it.
Sir, just one question for this is BD Ahmed and Venkatramani sir. I'm making it in a very broad question because then it will answer a lot of questions raised by the panelists. It is all to do with the Payment of Wages Act, Industrial Dispute Act, retrenchment, termination, the company can or cannot do, and are these government directions, will it hold a test of when it's tested in the court of law? I think I've tried to put it as broad as possible so that a lot of questions can be covered.
So Venkatramani may answer first.
Okay, I know judges is finally dispose it off. I think we covered the whole ground from very important angle. What the government has done by issuing various directives, by invoking the authority of law under the Disaster Management Act. If that authority of law is available, then we are bound by that. The question is there an authority of law available under the Disaster Management Act? But then before the courts will answer that, the courts may also go into a mediatory, conciliatory measure, saying, look here, what are the options available to the government, forgetting about the fine nuances of the law. The government has also some obligations under the Constitution, Articles 41, 43, so on and so forth. So right to life, right to health, and right to livelihood, decent wages, minimum wages, whole lot of them. So if government has some kind of an obligation under the Constitution, and the government can come and say, perhaps now I am not able to find out quickly an authority of law for what I am doing, but I will place all my authority of law under the Constitution. And in due course of time, will gather all my thoughts and put it into a law. Therefore, today, the government may heavily say, forget about the authority of law under the Disaster Management Act, but I have my executive power. I'll fall back on the Constitution and sustain this question. But it won't be easily answered. So there has to be some fine balance drawn by the courts also. So the courts may not be probably inclined to say that the workforce which is laid off, not by reason of your decision to lay off, not by reason of your decision to retrench or close, but by our decision. So then it's our obligation to come in and rescue them. So therefore, you have to find new jurisprudential basis for this kind of situations.
Right.
Looking at it, looking at this problem from a broader perspective, whatever has happened because of this pandemic has costs, and the costs are both in terms of life, liberty, and economics. Now, life and liberty are at the top because you cannot mortgage life or liberty for anything else. But now, looking at economic costs, the costs have to be borne by somebody. If a workman loses his job and is unable to survive, somebody has to provide for him to survive. Whether it is the government which provides for it, which again comes back to public money supporting him, or it is the person who had employed him earlier who provides for him. Now the question is whether the government, as Mr. Venkatramani pointed out, using its executive power, can ask a third party or a citizen, one citizen, to support another citizen. Because ultimately it comes to this. It is the role of the government to support its citizens. It may take and appropriate funds from the citizens through taxation, through cesses, through other means, through voluntary contributions. And it is the duty of the government to support all citizens who are in need of that support. But can the government tell one citizen that you support the other citizen? That I think is a little contentious, and I think that strictly does not fall within the Disaster Management Act, because the way you look at the Disaster Management Act is that it is essentially to manage the disaster which has taken place. There are all kinds of disasters which are spoken about in the Disaster Management Act, through earthquakes, through tsunamis, etc., etc., and ultimately it is through disease, a spread of disease, or a pandemic like the one that we have here. Now, how do you manage that disease? How do you mitigate it? The expression mitigation has to be construed in the context of the objective of the act. The objective of the act is to cut down the risk of that pandemic. That means we have to cut down the risk of it spreading to other people and to curtail it, contain it, and finish it. That is what is the need of the Disaster Management Act. Apart from that, the Disaster Management Act also talks of reconstruction and recovery. And there are specific funds provided for that, which nobody has talked about. I think it's section 54 or something. Those funds are there. And those funds are to be expended for these purposes itself, for rehabilitation, for recovery. So that is what the government needs to explore and employ. So while it is asking one citizen, I'm using the expression citizen for a company or a firm or a business, asking one citizen to look after another citizen, then when it is asking that citizen to look after the other one, the government should also look after that citizen whom is asked to look after the third citizen.
Right.
By providing certain measures, certain economic package, which has not happened as yet. We hope that it will happen.
Mr. Rajiv Chaube, can you please ask your question? Mr. Rajiv Chaube.
Good afternoon, everybody. And this question is to Justice Ahmed. Sir, we are actually faced with a certain situation where we are hiring a lot of contractors for various services. It may be security, it may be some maintenance. And during this lockdown, although the production is closed, yet we are making the payment to the contractors on the bill which they are raising. So we are faced with a situation where I have paid to the contractor and the contractor in turn has not paid to his contract labor. And now there are complaints which are being raised to the regional labor enforcement officer saying that we have not paid the wages and there may be a local problem. So we have to sort the issue. We can pay to the contract workmen. The question is that if the company pays directly to the contract workmen, can the contract workmen tomorrow claim permanency basis the fact that the company has directly paid? And I want the judge's view. I know that to claim permanency, you need an appointment letter and all. But if this matter comes to you as a judge, where somebody is claiming permanency basis the fact that the company has paid directly and hence there is a privity of contract or I need employment in the company, how do we deal with that? Or what precaution we should take when we are paying to the contract workmen? Thank you, sir.
See, so far as I look at it, this is a situation, if such a case would have come to me when I was a judge, I would have looked at it not from the perspective of ordinary times. I would have looked at it from the perspective of the extraordinary times that we are living in. And if you make a direct payment to somebody, you are essentially, what you are doing is paying the wages which the contractor to whom you have made the payment was supposed to do. And you are not directly employing that person. The employment is through your contractor. So I don't see how as a judge, I would have said that he is in your permanent master role or whatever it is. I don't think that would have happened. But if it goes on for a long period of time, that is, if it goes on for months and months, then you may have a problem, not otherwise.
Thank you, Justice Ahmed. Mr. Vikram Munje, please ask your question.
Yeah, I have, sir, one specific question. If we go to the definition of mitigation, it is a very widely defined term, which even talks about impact or effect of disaster. That is one. Two is section 13 of the Act, which talks about relief in loan repayments, etc. So this essentially provides for national authority in cases of disaster of severe magnitude, recommend relief in repayment of loans or for grant of fresh loans to persons affected by disaster. And as you, sir, rightly pointed out, section 50, which directly talks about mitigating aspects in terms of providing relief in financial relief. My specific question is this not under section 13 that government can come out with a package for MSMEs providing relief to workmen, which is very hotly contested issue in the Supreme Court with regards to payment of wages, etc.
Yeah, do I answer that?
Yes, please.
Yes,
Section 13, I've got it in front of me. It says relief in loan repayment, etc. The national authority may, in cases of disasters of severe magnitude, recommend relief in repayment of loans or for grant of fresh loans to the persons affected by disaster on such concessional terms as may be appropriate. So it's a provision which directs or allows the national authority to recommend relief repayment, and the call will have to be taken by the government as an executive, not as a part of the national authority under the Act. So that is one. The second thing is you talked about mitigation, and mitigation, as you rightly pointed out, has defined it in rather broad terms as meaning measures aimed at reducing the risk, impact, or effects of a disaster or threatening disaster situation. Now, as I said earlier, this essentially has to do with the management of the disaster itself, the risk of the disaster, the impact of the disaster. It is in terms of physical effects of the disaster. But if you take it much beyond this, and you say that you can use this provision of mitigation to ask one individual to pay another individual, I don't think that would be appropriate.
Just Ahmed, just to add on to what your reflection, if you can quickly look at sections 46 and 47 of the Act, there are two categories of funds. One is a disaster response fund, other is a disaster mitigation fund.
Correct.
And Parliament will have to by appropriation put funds into this. But if Parliament were to understand that if mitigation of disaster includes anything other than we are handling or containing the disaster, then of course the disaster mitigation fund must also be brought into effect. And somebody can say, as you rightly said, two private citizens having conflicting claims, the government will say, all right, I have a disaster mitigation fund, which must be probably expended for this purpose also. But if the government's understanding is wrong, namely that disaster mitigation is only confined to containing the disaster, then of course this doesn't follow.
Yeah, you're right. So if you look at the National Disaster Response Fund under Section 46, it has two sources. The first source is which the central government may, after due appropriation made by Parliament by law in this behalf, provide. And the second source is any grants that may be made by any person or institution for the purpose of disaster management. So individuals can contribute to this fund. I don't know what is the extent of this fund, whether it has been created, not created. I don't know. I'm not aware. So it could be definitely used for this.
Somya, any other live questions? Please have.
So yes, Akshay, could you connect to Mr. Deepak from G4S? I believe he has raised his hand to ask a question.
Sure. Mr. Deepak Sharma, can you unmute yourself and ask the question, please?
Can you hear me?
Yes, please go ahead, sir.
Yeah, I've got a question for Justice Ahmed. Sorry, sir, you are in a lot of demand, and I'm so sorry for that. Yeah, so just, sir, one quick question. If we talk about, Disaster Management Act, so like in case somebody non-complies with the MHA guideline, then it straight away takes it to Section 51. And Section 51 says whoever without reasonable cause. So that's what how it starts with. So as per you, what would be the meaning of without reasonable cause?
This is a question which lawyers fight day in and day out as to what is reasonable and what is not reasonable. And you will have to give us a specific situation.
So, for example, I'll just ease it for you. For example, if I am an employer, and as per MHA guideline 29th March, and as per that, the salaries of the employees need to be paid. So, in case for me it's not possible to keep on paying salaries to the employees because of the lockdown, because I'm not earning much. So will that become a reasonable cause, or still the court would go into the balance sheet and look at the profits, whether I've got cash flows or not, whether I've got reserves or not? So, so how you take it?
See, it's this translates into a question of fact. Now, in your case, for example, you say that you have to pay salaries or wages of your employees, and you say that you are not earning much. Now, not earning much is a very nebulous concept. If you, for example, have zero funds, let us take an extreme case. You don't have any money, and you are able to prove that you don't have any money, then that would definitely be a reasonable cause, because you're not expected to borrow to pay somebody. But the other thing is, we have to look at it in another aspect also, as to whether the direction given by the central government itself is valid or invalid. So that also can be tested, but that has to be tested only in a court of law. That is what I have been saying. But reasonable cause, if you have nothing to pay for, you have no money left with you, then obviously that's a reasonable cause. But if you have enough funds somewhere parked in some bank, and then you are saying, in this account I don't have money, but you may have money in some other account, and you still try to take the ground of reasonable cause, that may not survive.
Well, and sir, if you have time, like just one small question as well. So we've got about 3 MHA guidelines majorly, and other than those, others are like amendments. So we've got like one directive on 24th March, another one on 15th of April, and then the last one of 1st of May. So there have been a few SOPs which has been charted out in 15th April notification. And when I look at the notification for 1st of May, so whatever was covered in the 15th April SOP, so few items are not there in the 1st of May guideline. And for example, like as per the 15th April guideline, you have to actually maintain the insurance, health insurance for your employees. But when I look at the guideline of 1st of May, it doesn't say so. So it's not part of the SOP for 1st of May. So now, as a company, should I follow the guideline as per 15th of April, or I follow the guideline as per 1st of May? Because
the sum and substance of Deepak's queries, Your Lordship, is that when the MHA is coming up with guideline or SOP one after another, does the subsequent one supersedes the previous one?
See, if there are 2 ways to look at it. Most of the government notifications and guidelines always say that these are either in supersession or in by way of supplement 2. But if they don't say that,
right,
then the usual course of action that courts take is that the later one will prevail over the earlier one.
Yeah.
If the two contradict.
So I think we can take up one last live question from Mr. M.M. Sharma, and then we can go ahead with the closing remarks since we're running out of time. So Mr. M.M. Sharma, please go ahead with the question.
Am I audible, sir?
Yeah.
Oh, thank you very much. And it's nice to see Mr. Venkatramani, Mr. Lamba, and Mr. Ashish Chandra, and Meenu. I hope the greetings to you at this time. I have a question to both Mr. Venkatramani and maybe Lordship also would like to reflect on this. This is an academic question, but because we as lawyers keep on answering queries from people like you just heard, Mr. Deepak Sharma, so I'm specifically referring to the MHA order of 29th March under section 10(2)L of the DMA Act. Am I just reading out? Am I audible, sir?
Yeah.
So I'm just producing that L. And it's under this particular provision that the directions have been issued. Lay down guidelines for or give directions to the concerned ministries or departments of the Government of India, the state governments and the state authorities regarding measures to be taken by them in response to any threatening disaster situation or disaster. So I'm emphasizing on the last few words, that measures to be taken by them in response to any threatening disaster situation or disaster. So I believe that the order in this MHA order of 29th March, which its last part is restricts the employers from not reducing the wages or removing the workers. The word uses workers. Of course, there are legal interpretation of workmen and workers. I'm not going to that. The point I'm trying to make is this direction by the government under this act, which is an extraordinary power, and of course the situation demands that, can it be considered to be valid constitutionally as a reasonable restriction under 19(6) with respect to the fundamental right of trade? You see, for a employer who has all the expectations of earning so as to pay to his workmen. So my question is whether this would be considered, and I'm highlighting those words under the particular clause, would it be considered as something which could be linked to the disaster? See how the continuation of the employment is linked to the disaster, containing the disaster.
Yeah, we got that. Sir, we can just this will cover a lot of questions, sir.
So I'm requesting the experts. We have Mr. Venkatramani, senior advocate, please answer, sir.
To the answer, please. Yeah, Mr. Venkatramani, sir.
Look at you talking about measures to be taken by them in response to any threatening disaster situation or disaster. That brings into focus authorities at the state government level. Now, measures in response to any threatening situation, disaster, is a matter generally that should be within their understanding, comprehension, and discretion, depending upon the disaster in question. But since we are talking about a national level issue, it could not have been left to the discretion of each and every state to decide in their own particular way, peculiar way. Therefore, L has been brought in to deal with a national level provision of guidelines. The word guidelines and directions need not necessarily matter. They take color from the authority of the government to command a state government or a state authority to act in a particular way. If in the understanding of the central government, their understanding would be a most appropriate way of a response to a disaster situation. So therefore, instead of allowing 100 responses, emerging, the government said, my understanding will be a more comprehensive understanding of a response to a disaster situation. You are directed to act in terms thereof. That's how I think one can read that. But ultimately, the question is not, you can't see the reasonableness of it from the point of view of mere the wording or the phraseology. What exactly the impact on the persons who are affected by it? There are two persons affected by it. The workers who are affected by the lockdown or a measure, or the employees are also affected. Therefore, if two persons are affected, if the governmental action is measured on what parameters of reasonableness. So you have to fall back on either standard concerns of reasonableness under existing case law, or you have to say extraordinary circumstances will probably look for new distribution of obligations. For instance, during World War II in England, they had a Wartime Adjustment Liabilities Act. Liabilities adjustment is a very important concept they tried to play on for quite a long time under the wartime period. I think suppose we bring in some such concept, adjustment of liabilities, then classification, and then degree of bearing of liabilities, etc. I think that's how probably one can look at it.
Justice Ahmed, sir?
Yeah, section 2, 10(2). If you begin with section 10, it's actually not the government, but it's the powers of the National Executive Committee under the Act. Now it says, without prejudice to the generality of the provisions contained in subsection 1, the National Executive may. And then you come to L, lay down guidelines or give directions to the concerned ministries or departments of the Government of India, the state governments and the state authorities regarding measures. So actually these are guidelines or directions given by the National Executive under the Act to the ministries or departments and state governments. And if you look at the notifications that are coming out, I don't know how they come out from the Ministry of Home Affairs, but it is the National Executive who has issued these guidelines. And these guidelines are for strict, as they say, for strict implementation by the ministries, departments of Government of India, state, union territories, and state union territories. So essentially, these are guidelines not addressed to the citizen directly, but they are guidelines and directions addressed to the various departments of the government, both central and state, as also the union territories. And they have been directed in their turn to ensure that these are implemented. I don't know, we will go on to the legalities of all this much later, but as of now, this is how it is being done. The only issue that survives is whether whatever direction that has been given under this provision of section 2L is within the parameters prescribed under the Act or outside it. And that can only be judged and tested in a court of law. Even if I say it as a former judge, it doesn't matter. It has to be by way of a judgment by a court of law. And that's the only way in which this can be finally decided. I may have a view, Mr. Venkatramani may have a different view, but ultimately it is the court's view that will prevail, and that too ultimately by the Supreme Court.
Lovely. I would really like to thank everybody because, we have actually shot over more than 25 minutes of the time. And first of all, I would like to again thank Symbiosis Law School, Sadgamaya, our friends from Lux Fitness, and Somya, my colleague from THS. And it was a brilliant session. Thank you all for participating. And I don't want to give a concluding remark. I would request the panelists if they have to say anything before we log off. Manish bhai?
No, it's time. We have taken enough time. I think as Justice Ahmed correctly said, so ultimately the courts will have the last word. We can only give opinions, and by and large, this is a problem. I think we must wish our viewers, our friends, a very healthy and a safe period. Today, the lockdown may have been lifted, but the pandemic has not gone. We have to wait for a vaccine. We have to wait for better days to come. And I'm sure our future will be brighter than our present. That's about it all. And we all...
I would also request all the attendees, if you could just go through the polls, your witness, please. And, it says, how was your overall experience, etc. Kindly do that before you all log in. And Ashish and Meenu, concluding remark?
Yeah, no, just wishing everybody stay safe.
Yeah, same here. And I think I just want to sign off with an optimism, like Manish said, that I hope the future is more bright. I think this post-COVID world should be better than the pre-COVID world. Let's all work towards that.
Alok, I really want to say that I think the whole idea of this webinar was to generate, out-of-box thinking.
Right.
And of course, we will explore alternatives beyond frustration.
Right, sir. Somya, anything else you want to say before we close?
No, sir. I think just
okay.
Pray everybody stays clear.
Thank you. Thank you.
Thank you. Akshay?
Thank you so much, sir. On behalf of
Thank you.
we thank all the panelists.
Thank you, Justice Ahmed.
Justice Ahmed, thank you so much. We will end
Thank
the
you,
meeting
Akshay.
now. Thank you so much. Pleasure.
Thank you, everyone.
Thank you so much.
Thank you. Bye.